those who do not know, my name is Ryan, and so I get to kick this off. But you guys have a special privilege today. Two other of the associates here will be doing much of the talking. Oh wait, that's my privilege. But they're very good. We have a very good topic today. It's good to see you all here. And we will be looking at feeding and caring for your estate plan, whether it be a will or a trust, and why is that important. And so we have 3 goals for today. One is to dispel myths. People hear a lot of different things about estate planning, about wills, about trusts, and what you should do with them, and not all of what they hear is actually accurate. So it's actually rather interesting to hear what people have been told. So today we're going to really try to clear up a few of those. A part of that is asking questions. A part of that is either raise your hand in the middle of it, or else write it down and in between different parts of it. At the end we'll have time for questions. A second thing is to help you help yourself, help your family, help your friends. And apparently it's for you, it's all 3. Thank you. The reason we say that is because what we have to talk about today doesn't apply to everybody. Some of you may have a will. Some of you may have a revocable living trust. So you may think some of that doesn't matter. However, you may have friends or family that have those types of things, and it's important that you have the right information. Even to the point that we make extras of these. If you have someone that needs to hear this, feel free to give it to them. And apparently we're videotaping it. So it will be on our website somewhere, or YouTube or something. Ask later, they'll tell you. The third of the main goals is to be a resource to you. That what we do is we are here doing estate planning, and for our clients and their friends and their family, if questions come up, call, email. We don't charge for those because it's more important to have the right information. So I'd like to introduce a bit of our team so you get to know what we're doing. Michael, you've been meeting some of you have met Michael. It's a privilege having him here with us. Amber's hiding in the back. Just give her the worst time in the world when she's up. This is her first seminar. So we give grace in the office. You don't have to. But we have our other team here also, and these are the ones that make sure things happen. So Caleb's managing the camera back there, so we apparently have to be nice to him. We have Kari up here who's going to take care of all this stuff. Oh, that's Kari. If you've known me for very long, you know the worst thing in my life is names. Over here we have Heather, and for those of you who work with me, you know Carol. She's the gatekeeper. You definitely go to her if you have any questions for me, because she hunts me down. So it's really good. There's more team upstairs. If you've never been to our office on the 3rd floor and you want a tour at the end, come on up. It's a pretty cool office. And the team helped to create it, so if you want to figure out where they all live, come on up afterwards. So how to care and feed for your trust is an important thing. Most all of you, I hope, read. And so I'm not going to read the agenda because you're going to get into that. But why? Why is it important to do this? Well, it's important because life happens. I don't know how many of you have young kids. Anybody with kids under 18? Okay, don't blink. They become 34 and 31. I don't know when, but it did. And their goals and desires change. What they're now doing for careers are not. And what is happening in their life makes a difference. Other things occur about desires and goals. And one is, we have a grandchild now. How's that going to affect things? And that's something we'll be talking about today. Another thing is tax laws change. And we'll be looking a little bit at that also. But there's not just the issue of income tax. That deals with capital gains. But the things we're going to highlight is what the changes they made on estate taxes. And we actually did a bit on estate taxes in one of our other seminars. If you'd like more information on that, definitely talk to Amber afterwards, because Amber will be able to direct you to get to that seminar on our website. Thank you, Amber. Much better than that. Another thing is assets change over time. I was talking to a client that is meeting with me, and they said, I have no idea how I got this much money. I'm thinking I know how to help you get rid of it, but that's a different issue. And so they're looking at it now where in the past they've not had a state of Washington state tax problem, and now they do. But when they talked with us and learned about the tax laws, as a couple, they realized, hey, we don't. And that was really relieving to them. So different types of changes may affect what you're doing. And if you've been with us for a long time, estate taxes were $600,000, everything over that. Now it's $3 million. I like this stat, but that's huge. And some estate plans were done back then and never updated. Why we talk about Karen giving your estate plan. A couple other things. Your assets may have changed, but your beneficiaries may have changed. Who do you want to leave it to? I mentioned I have a grandson. I can go tomorrow to Spokane. He's in a hockey tournament. I'll be able to watch 3 of the 4 games. We're ecstatic. I never would have imagined I would have a 15-year-old grandson, 3 inches taller than me, and anybody else in the immediate family, who's a hockey goalie, who's being courted to go professional. Okay, whose kid's that? It's not my grandson, because it came from my son. He's our problem child. So your beneficiaries may change. The sad ones is when a beneficiary dies. If we learned nothing in COVID, people quit agreeing to die in the right order. And so now we have situations where beneficiaries we want to leave something to are not. One of the amendments that we're coming up with is the person who has no children has 11 nieces and nephews. That's great. Called me up a few weeks ago. I have 10. Oh, let's talk. And because it did change. And then she said, and now some of them have kids. I want to include them. She hadn't thought about that because when she did it, she didn't want to. But her beneficiaries have changed and her goals and desires have changed, which is the last one there. That proper estate planning not only should give you peace of mind and control, but proper estate planning is based on your goals, your desires, not your kids' goals and desires. Sometimes not your parents' goals and desires. It needs to be yours. And so we'll be doing a little bit of challenging to you today of your goals and desires and how you want them to be met. Okay, so with that, Michael.
All right, well, thank you, everybody. I've gotten to meet a few of you before we kicked off today, and some of you gave me some great questions. So if you hear your question, I'm not going to point you out or anything like that. You can remain anonymous. If you have a question, feel free to throw a hand up, okay? I'm a former school teacher. I love an interactive room, okay? Keep things moving here. We're going to talk a little bit about when to review your plan. Amber's actually going to talk about the details of timelines and events that will trigger when. So if we move to the next slide here, we're going to talk about things that we want to keep in mind specifically related to wills. We're going to start with wills, and then in a few slides we're going to switch and talk about things to think about when we're talking about trusts. So in all of this presentation, you're going to find something here that applies to you guys. So in order to get us started here, I like to tell people that when we do estate planning, we focus on 2 things. We focus on our people, and we focus on our stuff. We're going to talk about people first. Okay, so in our wills, we name an executor or a personal representative. Those terms are somewhat interchangeable. But this is that key person that you're going to lean on and rely on to make sure that your plan is executed the way you want it done. So they're sort of the quarterback after you're gone to make sure all of your wishes get honored and respected and fulfilled. So it's kind of an important job. And when we meet with people and we put their plans together for the first time, we ask them, we challenge them, who are the people that you trust most to do this for you? But as time goes on, sometimes they prove themselves to maybe not be the trustworthy or responsible person we wanted them to be. Or maybe they were rude and up and died on us and got themselves out of a job. So whatever the circumstances might be, this is one of the areas that we're going to ask people to go back to on a regular basis to review. Do I have the right people filling this job for me? If you don't, that's a great time to come back and talk and update things. We try to create a list, a team of people, maybe in a certain sequence. If this person, number 1, that's my top pick. If they're not able to do it, and they say, no thank you, I can't take that responsibility on, we move to the next name on the list. Some people are shocked to hear that. They go, well, wait a minute, I put them on there. They better do that job. It's just the nomination. They don't have to take the job. We can't indenture them to servitude for us. We have to respect their autonomy here a little bit and give them some choice. So generally we recommend who's your top choice and come up with a couple of backup names. And so as you look through your documents and you maybe see, I'm really leaning heavily on this one person, that may be a weak point to your plan. And we want to consider adding maybe a couple of backups there to make sure that this is a little bit more robust of a document. Sometimes we might have run out of names. Our whole team that we put down on that list, maybe we have outlived all of them, or they've moved away, or they just for whatever reason are not going to be good candidates for us anymore. That's a red flag. We really need to talk to you to make sure we get some names in there in place. Because when you don't have someone nominated, you're giving up some control. Part of the estate planning process with a will or a trust is to be in control and have your wishes honored. So if we don't have someone you've specified to fill that position, we may be left to someone who races to the courthouse first with your will and says, well, they're all gone, but I'm willing to do it, and that may have been the last person you wanted to get involved. And so that's something that we want to pay attention to. We actually had a similar situation come up recently where we came across a family, they had found a will, and they went through the list of all the personal representatives. And there were 3 names, 2 of them had died, and the last name said, I don't want to touch this with a 10-foot pole. Okay, now we're out of a personal representative who's nominated. Now we got to find somebody who's willing to take this position. And again, that might not have been what our person wanted when they put that will together in the first place. So always be cognizant of that. The other thing we pay attention to are not just the people we put in charge, but the people we're trying to benefit. Our beneficiaries, our heirs, sometimes our kids, our friends, our family that we're leaving our assets to. So guardianship provisions are extremely important for those who set up their plan when they had young children. This is our most important resource in the entire world, our kids. We want to make sure we name somebody who's going to step in and do that hard work for us of raising our kids if we're not in the picture anymore. Probably one of the hardest provisions for most families to think about when they're putting their plan together. I know it was for my wife and I'm in the industry, so we struggle to talk about who's the right person here to be guardians for our 2 kids. And we're not out of the woods yet. One's 18 finally, but I still got a 15-year-old, so I still got to outlast a few more years here. Make sure we don't need that provision. So as time goes on and our kids grow, sometimes we have to rethink who's the right person to raise our kids, to be guardians for them. I'll tell you, when my kids were infants, our main concern was, because I moved out here from the East Coast, I don't have a lot of family out here. It was really relying on my wife's parents. I hope they're around to cover the bases here for us if we needed them to. But then we had to think about who our backups were. And they were other close friends of ours, or they were my sisters who lived on the East Coast. When they were infants, that was okay. I was uncomfortable with that plan. As they got older and they started to build support systems around themselves, their classmates, their friends, their neighbors, their teammates on their swim teams and all that, I said, well, gosh, if something were to happen to us, I really would not want to rip them away from their support circles that they've built for themselves. I want to find someone who's more local who can kind of keep them in these same neighborhoods and in these same circles so that they're getting that support to lean on. They've just lost their parents. They need somebody that they're familiar with, rather than just pick them up and dump them in New York where they get culture shock. We need to figure that out. So that's an example. We want to figure out what that need looks like as it changes. As the children that we are raising grow up, we're focusing on the right individuals, the communities that they're going to be part of, the values that these individuals have. Are they going to be raised the way I want them raised? Are they going to be someone who believes the same things I believe, or will help nurture them in the ways that I think my kids should be raised? All of these are important factors, and they're all unique to each of us. So again, we want to customize this to make sure that your preferences, your belief systems are honored here as part of your guardianship provisions. And then as your kids reach 18, this provision starts to fall by the wayside. We don't pay attention to this as much. And we're focused now on they're adults. How do we treat them as adults? What are their needs at this point in time? Are they mature? Can we leave them an inheritance right away? Sometimes we're fortunate, we can do that. Sometimes we might still have some lingering concerns that we're not quite done baking this one in the oven yet. We need a little bit more time to get him where he needs to be. And then the plan might evolve. We might start adding trust provisions to make sure that this young person still has a little bit of a safety net around them. That we're leaning on a trustee who can then look out for that person to make sure that as they're reaching 20, 21, 25, or whatever age you might specify for them, that we have a safety net in place, someone who can take a look at the situation and stand in our shoes. I'm not here anymore, but my trustee, I've selected them because of their discretion, their ability to think through situations and try to do things the way I would want them to do. So that's another example of how the people are at the center of our plans. Now let's talk about some of the stuff that we leave behind. Okay, our asset distribution changes. Sometimes that may change because what we owned at the time we put our will together looks different now, umpteen years later after we put our plan together. We buy, we sell, we acquire new things, we get rid of old things. And so we want to make sure that our plan is appropriate for the assets that we're holding at the present time. Anytime we're talking about a will, we're talking about our best guess for the future. What can we reasonably foresee into the future? What's our best situation for the immediate? If something happened to me tomorrow, what do I want to have happen? And can I look to the horizon a little bit and get a rough idea of maybe what the next 5 to 8 years look like? And if I can, great. Then I can really take a look at my assets to make sure that I'm distributing them appropriately to the people that I'm trying to leave things to. Yeah, let's go back one more. Okay, so then our last bullet point here is coordinating our will plan with non-probate assets. Non-probate assets, what does that mean? Let's break that down. So probate is the process that our estate's gonna go through when we have a will. Our wills are a ticket to the probate process. But sometimes we might own things that don't have to go through the court system. And those things might be a bank account with a beneficiary designation on it, or a retirement account that names a spouse as a beneficiary, for example. Those things just get handled directly with different financial institutions. They don't go through probate. So when we talk about coordinating our will with those non-probate assets, we want to make sure that we are taking into consideration what covers what. The will doesn't tell us what to do with those types of accounts with beneficiaries. That financial institution who's managing that account with the beneficiary will not even care what my will says. They're just gonna wait for someone to walk through their doors, present them with a death certificate that says, Michael's gone. Did he have anybody on these accounts? And they fill out some paperwork and they say, yeah, he did. He left this to his 2 kids. Well, great. They're gonna just cut the check directly to those kids. They're over 18. If not, that's a whole other story. But we just wanna make sure that your plan takes that into account. I have talked to a lot of folks in reviewing their wills over the years, and their wills said, hey, I want everything to go to my best friend. And then we talk about, okay, well, what kind of assets do you have? Well, I own a house, and I have this bank account, and I have this investment account. Great, let's look at the bank and the investment accounts. What do those documents say? Do you have beneficiaries with those institutions? Gosh, I don't know. Let's go look. Let's see what's on file with them. And it turns out, those accounts did not name the best friend like he wanted. They named his mom, because he set this up way back on the first day of his job and never looked at it again. Well, mom passed a few years ago. And so this was now gonna be a situation where there was uncertainty with his plan, and it wasn't quite up to speed with what he wanted. And so taking the time to review these things to make sure that what you're trying to do here matches what you're trying to do here. All right, we'll go to the next slide now.
Question,
Yes, thank you.
So if you do have an asset like that and the beneficiary is not alive, what does the financial institution do?
Yeah, that's okay, great question. So if we had an account that used to have a beneficiary, but we run out of named beneficiaries, what was formerly a non-probate account that would just go directly to the beneficiary becomes a probate asset. The institution, the bank will say, we don't know who it goes to, we need to get a personal representative to tell us, and we're gonna follow the person's will at that point. So, but what might have been a very quick and easy process, where it took a couple of weeks to get money into somebody's hands, now is gonna take longer. It's gonna go through the probate process and take maybe up to 9 to 18 months to fully administer.
I imagine there could be tax consequences of potentially depending upon the type of account too. That's probably beyond this.
There's always those types of considerations to take into account, and that's gonna vary depending on the circumstances involved here. So we're gonna kind of continue the conversation having to do with beneficiary designations. Okay, when it comes to wills, again, I like to make sure people hear this multiple times. Your will does not necessarily control these types of accounts if there's a beneficiary. If you have a beneficiary on your account, that will trump anything you have listed in your will or listed in your trust. Let that sink in there for a bit. So it's really important we come back and we review these things periodically to make sure we've got the right people in the right place to make sure things happen the way we want them to. There's a lot of horror stories that I've come across over the years. There is the person who set up an account and they name their spouse to be the beneficiary. Okay, nothing wrong with that. And then a couple of years go by and they divorce. Okay, but they never went back and updated their account. And so now they have an ex-spouse as the beneficiary of a retirement account. And this is an interesting little provision here, because now we get into a situation of, well, what does Washington law tell us, and what does federal law tell us? Depending on the type of account involved, Washington might say, oh, we're gonna treat the ex-spouse as if they're dead. A lot of people celebrate that. They go, yeah, they're dead to me too. I don't want to have them get anything. But if that account has some sort of a federal connection to it, federal law would trump Washington law, and that says, no, we're gonna still give it to that person. And so I have seen situations where the ex walks away with this account, and that was the last thing that the person wanted. And so who lost out in that? Well, the person's kids is really where he wanted it to go, but the ex walked away with all of it. So those are important things to take into consideration here. Coordinating those designations with the will, making sure that we're trying to get a plan that addresses both probate assets, like real estate, as well as non-probate assets with account designations. Retirement accounts and life insurance accounts are great examples. These are where we see a lot of problems, like I just explained here, with the man who left everything to his ex. We also see sometimes where a person will sit down with an insurance advisor, and they say, I need life insurance, okay? They're happy to sell them a life insurance policy, and they go, well, I want to name a policy for my wife, okay, we can do that, and I want to have a policy for my 2 kids. Great, what are their names? And they fill it in, and no one asks the question, well, how old are your kids? Oh, the kids are 4 and 6. I had this happen a number of years ago, and so the insurance company, when that person passed away, said, well, we can't pay out to a minor. We've got to get a guardian appointed to manage these funds for the minor. Oh, the surviving spouse was left in charge of trying to set all this up and realized, well, I'm their guardian, I'm their mother. Yeah, we need someone who's appointed by the court to be accountable for receiving these funds. And we need to go through this whole guardianship process. Ooh, that was a hard conversation to have with that family, because they thought they were doing the right thing. They thought setting up life insurance was a good idea. It was, but there was another layer to their planning that they should have had. If they had coordinated it with their will had a provision there that said, if my children are under the age of 18, I want this person to be in charge. They could have named that trustee of their children's trust on the life insurance policy to receive those funds, and we would have avoided all of those headaches. So sometimes it's just kind of a case of, you need to ask a little bit, and sometimes I put a little blame here on the advisor for the insurance here, who didn't ask the question of how old those kids were. That was a big miss on their part. How do we avoid conflicts between documents? I might have alluded to this already here, but your will says I want to leave it all to my friend, but the document says it's going to my mom. Well, that's a difference here. We want to make sure that we avoid those kinds of problems. So anytime you're putting together your estate plan, or anytime you're having it reviewed, that's a great time to go and pull any of these accounts and see what's on file. Who are the beneficiaries currently in place so we don't miss something? Let's make sure that we get another set of eyes on it periodically to make sure that it's exactly what you want. Because your goals might have changed, your wishes might have changed. We may have had something happen to one of those folks here that you've named as a beneficiary. We want to make sure it's the right plan at the right time. Ensuring updates after major life events. Again, life throws us curveballs on a regular basis. It's the people that we've relied on, it's the people we want to leave things to, and then they just die in the wrong order, and something happens to them. That's the most common example. Somebody in the room asked me to talk about, well, what happens if we had a falling out with a relative and we don't want to leave things to them anymore? Such is life, it happens. I deal with that all the time. There are ways of addressing that. So one, we want to find out, are they named as a beneficiary on one of your accounts? Let's remove them right away from that. And then we go back and we look at your will. Are they named in the will to receive something? If you don't want them to receive that anymore, we need to get them out of there as well. Now, if you want to go an extra layer to say, I want to make sure they don't receive anything at any point in time ever belonging to me, we want to make sure we write that specifically into the will. This person is now excluded. They are not to receive anything from my estate. And you'll all have your own reasons for making those kinds of decisions. It's our job to help make sure that that is enforceable, that that is going to hold up, that they cannot come and start litigation against your estate and end up receiving something when you did not want them to. And we have experience doing that. Now let's talk a little bit about things we want to keep in mind when we start dealing with trusts. A lot of our topics are going to be similar. We're still going to focus on the people and the stuff. So when we talk about trusts, our key maintenance areas, we'll start with people. In the wills, we talked about the executor, the personal representative. In the trust, we use different terminology. We're going to talk about our trustees and the successor trustees who take over. So this is going to be the person who's in charge, who manages the trust for us if we're not able to, or if we're out of the picture. So again, creating a list of people who are going to be our top person that we rely on, or maybe a couple of people who are going to work together as co-trustees. You can do that. We want to make sure that you've got the right team assembled to help you when you need them. And so as life goes on, we may encounter having to do an update because so-and-so moved out of the area. Somebody else was inconsiderate and died on us. Someone else, I had a person come talk to me recently. I just put this plan together a couple of years ago, but I saw how this person handled the crisis, and I do not want them anywhere near my plan anymore. Oh, better to learn that now. Better to have someone show their true colors in advance when you have the ability to change your plan and say, on second thought, I'm going to name so-and-so instead. They're going to be the person I lean on and trust as my successor trustee. This other person, they don't share my values. They don't handle things well under a crisis. They were not reliable. So again, we try to set these up so that you can come back and make the changes that you need to when the moment strikes.
Question?
Yes.
Can an organization, say Braeburg Law, serve as a trustee, successor trustee?
Absolutely. It's not just any company. I mean, there's going to be certain characteristics and certain qualities you're going to want to look for, but there are professional trustees out there, and our firm can serve in a capacity here to be a trustee for your plan. I think this will get addressed a little bit further on, but a sneak preview. Oftentimes people will consider who are the family members I might turn to be the trustee? Who are the friends and other people I might turn to be a secondary trustee if I need them? And if I run out of those folks, maybe I consider naming a professional trustee towards the end of that list to kind of be the backstop to make sure that we don't run out of names like we talked about. All right. Other areas of funding the trust. We're going to talk about funding the trust here on my next slide, so I'm going to pause for that for just a moment here. But the tax considerations, Ryan kind of alluded to. We're going to have situations where tax laws change on us. Sometimes the changes are good news, like we just experienced here, where they say, let's raise the exemption amount and you get to protect more money from estate taxes. Those are lovely conversations to have with people. We did a whole seminar about that about a month or two ago, and that's available for anyone who wants to view that. I was one of the talkers for that presentation there. But sometimes yes, sir?
Are those seminars online?
I believe they are available on our website. And if you have trouble navigating that, we can make sure we send you a link to it. If you check in at the end here. But sometimes the structure of our plan doesn't talk about what the tax exemptions are. They just say, we're gonna use the tax exemptions. And so that allows you to kind of have flexibility in your document. And so when you're looking through your plan and you're going, well, I don't see $3 million listed, do I have to update it? Well, certainly come talk to us, but we'll point out where it says how you're covered and how you're protected to give you peace of mind. But if you're not sure, some of the older plans that are out there from the 90s or so, they had very specific calculations and percentages and fractions and very convoluted algorithms that you had to go through to figure out, well, how do we deal with the taxes? If you have convoluted language like that in your plan, it's time to come in and talk to us. Let's make sure you get something updated so that it's easier to understand, easier to read, and it's going to be better to administer for your plan. So those are things that we kind of take into account here. Distribution guidelines. That's our last point on this slide. So when we're leaving instructions for how to distribute our trust to our family, to our friends, to our charitable organizations, or anybody that you want to leave things to, sometimes we have a change of heart. Sometimes our assets have grown and we can be more generous and include more people than we would have thought originally. Sometimes the reverse happens. We've been consuming and we've got a smaller pot to work with. Whatever your circumstances are, it's always a good idea to come back and look at. Am I giving things to the people the way I want to? Am I giving them the right percentage or the right dollar amount? Does this still feel good to me? So sometimes I get a lot of questions. Is this the right thing to do? And I usually answer, well, is it going to help you sleep better at night? Because that's ultimately what I measure a lot of our success by, is if it is accomplishing your goal and accomplishing your wishes in the way that makes you feel good, then you're the only one that can tell us whether that's the right approach for you. These programs and these documents we put together, they are not one size fits all. All of these things get customized according to what your goals are, what your plans are, what your priorities are. We want to make sure that throughout this whole process, from when you started to when you come back and talk about us updating or revising things, that your wishes are always heard throughout the entire process. And so that goes according to these distribution guidelines. We want to make sure you're giving things to the right people in the right amounts at the right time. So sometimes we might have provisions in here that say, I want to leave things to my kids, but I don't want them to get a big chunk all at once. Because if they are anything like me, they're going to go out and spend a bunch of money on a shiny red sports car, and then they're going to probably wrap around a telephone pole. So I'd rather that we dole it out a little bit more slowly, that maybe they can get a lump sum to start with, learn from it. Maybe if they make some mistakes, there will be more coming at a future time. Maybe we dole it out every 5 years and give them a little chunk to be more and more responsible with. If that sounds good to you, and that's not already in your plan, you can put those provisions in at any point you want. If you have those provisions in your plan now and you go, I'm not worried about that anymore, they grew up and they're pretty responsible now, we can take those provisions out. Again, it's all about fitting your needs and your goals and the needs of your beneficiaries. On that, I got another point here. There was another question that came up having to do with individuals who may have special needs. We may want to make sure they have certain provisions in place, so that way if we were to leave them an inheritance, they don't get disqualified from a benefit program that they may qualify for. Maybe they've got housing provided for them, or food stamps, or some kind of a program that's providing them with housing and services and care. Well, a lot of these programs are based on assets or income. And all of a sudden, if they get a big windfall inheritance, now they have a lot more assets than they did before, and that could kick them off of their benefits. So if that is a situation that is important to you, we want to make sure we look at your plan to make sure that there is a plan to address that. Sometimes we don't always know that an individual is going to have that need when we've set up a plan for them initially. So we may need to introduce that special needs trust or a supplemental needs trust into your document at the time we learn about it. So that way we can be sure that we can still include somebody because we love them dearly, we want to care for them and leave them something, but we want to do it in the right way so that we don't inadvertently trigger stopping of their benefit program. That would be catastrophic for a lot of individuals like that. So the more we know, the more we can help assist in that. Questions, sir?
Can an individual deny an inheritance and thereby avoid a situation like that?
Yes. It doesn't come up a lot, but we will have individuals who sometimes go, no thanks, I don't want to receive anything. And they have their reasons. Sometimes it may be related to a benefit program like that. But sometimes it's just I've left this family and I don't want to have anything to do with you guys. I've seen all kinds of circumstances like that. But there are ways to do that. We hope that it's rare, so we hope that doesn't happen too often, but there are specific things that we need to do to make sure that that's done within a certain timeline. Usually someone has 9 months to decide whether they're going to disclaim an asset and say, no thanks, I don't want to have anything to do with that. Sometimes it's part of a larger plan of something they're trying to accomplish. So that's definitely a time someone should come and talk with an attorney and go, how do we handle this?
And what typically happens to the money if it's denied?
When someone says, no thanks, I don't want it, we treat that person like they've passed away. And we look to see whether the document tells us, what's the alternative? Where should this money get rerouted? And so there may be a solution already in the document, we just need to explore to figure out what the nuances tell us. Yeah, great question, thank you. Thought I saw another hand. Let's move on to the next slide here. Funding the trust. Well, hopefully, when you set the trust up, you spent some good quality time trying to figure out how do we put assets into the name of the trust so that the trust is going to fulfill its main accomplishment or its main goal of avoiding probate for us and keeping life simple for our friends and family and our heirs who are going to benefit from this later on. But sometimes the assets we started with are not the assets we end up with. So maybe the house that we purchased when we set up the trust clearly went into the trust. We had assistants putting that in there. But over time, they decided, oh, we're going to relocate. We want to move to a different school district, or we want to downsize now that the kids are out of the house. So they sell the house and they buy a new one. Are we sure the new house got into the name of the trust? If you're not sure, let's double check. And this is a classic example of ways we want to review to make sure that the trust is still up to date. And so the house, or when we switched from Fidelity to Charles Schwab or to Vanguard, did all of the settings and the controls on those accounts, did they carry over as they moved? Are they still coordinated with the trust the way we want them to be? Doesn't hurt to look, doesn't hurt to ask the question. I'd much rather spend some time talking about that with you and reviewing things to make sure it's exactly what you want. The reason this becomes so important here is because of that second bullet point. If the assets are not properly coordinated with your trust, either in the name of the trust or naming the trust as a beneficiary at the appropriate time, there is a risk that a probate will be necessary in order to handle those accounts. And then you're going to have someone who's gonna be mad at you going, well, I thought you set up the trust to avoid probate, why are we going through probate now? And you don't wanna have someone look at it and go, well, they forgot to update that account, they forgot to switch the house into the trust. Because these are things that can be avoided. And that's why we encourage you to regularly take moments to check in with us, do a free checkup appointment, let's just take a look at things, make sure we're on the right path here, to make sure that these things don't get missed, that we have eyes on them periodically and on a regular basis to make sure they work for you.
I have a question.
Yes, sir.
Can you, address, Washington taxes as they apply to trust?
So our main thing that we talk about when we're dealing with taxes in this arena is we're focused on estate taxes. And so we've mentioned a couple times here where Washington recently reset its estate tax threshold, where now you have to have more than $3 million before the estate tax kicks in. And so with careful planning, a married couple can each protect $3 million, as long as we're setting it up the right way, and trusts are a big part of that, then we can protect up to $6 million. Okay, so when we have a situation where we exceed that, then we'll go into a lot more detail to figure out how your circumstances might be addressed, depending on your comfort level with paying the government tax money. Okay. Thank you for that. So part of our review process when we're talking about trust is going back and looking at some of these funding documents, reviewing the real estate, the accounts, and businesses. A lot of times we'll have folks who have set up an LLC over the years because they started to rent out a property that they acquired. Well, we can work with you to make sure that that LLC interest is part of your trust. So that way we can avoid having to go through probate in order to transfer that business interest. That's one that gets often overlooked, so I like to highlight that. Yes, sir?
I'd like to have an answer on what the percentage tax rate is over the 3 million.
It's a tiered system, so it depends on how far above that 3 million we get. It's gonna start at 10% for the first million over, and then it jumps to 15 and 17, all the way up to, what's our max rate now? Are we at 40? Yeah, our max rate, when you get to about $9 million over the $3 million exemption, that chunk will get taxed at 40%. And so it's a progressive tax, the more we get over that threshold there.
And it's more progressive than it used to be.
Oh, yes.
After the 3 million, they caught up with the after.
I like to say that when we deal with taxing authorities, and they give you something, they usually take something in return. It's some sort of a deal with the devil. So they allow us to exempt up to 3 million, but then they tax the higher amounts at a little higher percentage as well. So there's a little give and take there for sure. All right, are there any other questions about funding the trust? Yes, ma'am.
At what point do you know if you receive a will or you should have to trust?
That's a great question. And we have,
In your estate,
the question is, at what point do you know whether you need a will or whether you need a trust? And that is the cornerstone of every one of our beginning conversations with a new client. We'll go through the steps to consider in terms of, are you worried about an upfront cost versus a long-term cost? Are you worried about trying to make life easier for family and heirs who are going to benefit from things? Are we focused on how much information is publicly available versus being privately held? So there's a lot of factors.
It's not just like how much assets you have.
Absolutely not, no. The asset level is not a trigger for whether you want a will or a trust. Yeah, that's a frequent myth or misunderstanding, so I'm glad you raised that question so we can kind of dispel that. There are presentations that have happened over the years specifically on that issue, and so I would love you to come and take a look at the website here and get that more information, or come talk to one of us afterwards and we'll be a little bit more specific with you. Yes, sir?
Could you give us an estimate of the range of the will cost and the trust cost?
Oh, that's so hard to do because, like I have been saying here, every one of these plans is customized to make sure that we're getting your specific concerns addressed. And so there's going to be a pretty wide range depending on what someone's asking us to do. And so it's really hard to kind of give that information without sitting down with you more specifically to find out what's important to you. But every one of our consultations that we do with a person, will at the end include a detailed discussion for that person's specific concerns and what they're asking us to do. So at that point, we can definitely give you very precise quotes as to what this will plan might cost versus that trust plan. And then we can figure out for you what feels most appropriate. Great question, thank you for that. Please.
Are those consults, is there a cost to that? I don't
No,
remember.
you can come and sit down and talk to
Okay,
us,
okay.
free of charge, just to kind of learn a little bit more and figure out what is appropriate for your needs. Absolutely. Yes, sir.
Could you give us some examples of what kinds of items are not included in the trust, if you have a trust?
Yeah, we go through that based on your specific assets, but as a general thing, there are certain things we don't typically put inside the trust. Personally, I don't like to put vehicles in the trust unless it's some sort of a collector car that you're really not driving around. But your daily driver vehicle, I usually view it more as a liability than an asset. And so I don't really want to introduce that vehicle in your trust where if it gets into an accident, that injured person is going to bring a lawsuit against the owner of the vehicle. And if that owner is your trust, well, now you've just invited all kinds of litigation dealing with your trust, and I would try to avoid that. So we try to keep that outside and then have your auto insurance be your first line of defense of dealing with any problems that might come up from that kind of an accident without having to get all of your other trust assets involved. So that's just one simple example, but we would really go through a lot more detail to kind of figure out in your situation, are there accounts that may have certain tax benefits of going directly from the institution to a human named beneficiary where we don't have to get the trust involved with it. So we coordinate every one of our advice on assets here to make sure we're
Do you ever
customized.
put 401Ks and,
Yeah, there are things that we generally will do or not do, but there's always gonna be specific circumstances where we might consider doing it, and it may be a one-off situation. But 401Ks is another example where it may make sense to go directly to a named beneficiary. But if that beneficiary has a special needs trust or has a requirement that we have to hold it aside, we might need to route that through the trust in order to get to that outcome. So it's gonna be very nuanced depending on what you're trying to accomplish and who you're trying to leave that 401K to, but we would definitely work with you to figure out what the appropriate steps are to tailor that. Brian, did you wanna jump in on that?
A little bit later in one of the slides where we're talking about getting prepared for coming into a checkup, I'm actually go through a list of several different types of assets and how they are affected or are not affected by your trust or will. So we'll be covering a little of those in more detail a little bit later.
Thank you, appreciate that. All right, you've heard me rattle on here long enough. I'm gonna turn things over to Amber here to kind of continue our presentation.
Hello. So Michael kind of walked you through what the difference between a will and a trust and how to fund certain ones, beneficiary designation. And so I'm gonna talk about more so in regards to once you have something set up, how often should you review it? We say every 3 to 5 years, because if you think about it, 5 years ago was 2020, and that was COVID, and life looked very, very different than it currently does. And so a lot can happen in that time frame. However, there are times when we say it might be better to come in sooner, and that's that list that we have in front of you. So birth, marriage, divorce, building disease, or a death of a loved one, or anyone that you may know, whether it affects your plan or not, it may get you to the point of, hey, let me take a look at what we have. Let me see, does this still meet my needs? Do I still trust these people to do what I want them to do? And so it's really important, even if it's just opening the binder and being like, yeah, I still really, that still feels really good, then great. That's amazing. If questions come up when you're reviewing it, you can always reach out, as Ryan and Michael have both stated, that we don't charge for phone calls or emails. So if you wanna go ahead and ask, hey, this kinda happened, is it gonna affect my trust if I have them as a backup? Or is it gonna affect my will? We can help you have that conversation, and if it's a longer conversation, then we would go ahead and set up a meeting for that one.
You don't have listed moving, so if I wanted to move to a different state, I would think that might be a major event?
Correct.
Okay.
Correct. If you want to move, and for example, if you have a will and you move to a different state, you are definitely going to want to take a look at what meet an estate planning attorney there and see what the benefits and pros and cons of their specific state is. Because they may have different tax implications as well. So in this state, it may be great, you don't need a will because our tax estate exemption is 3 million. But for example, in Oregon, it's only $1 million. So that's a very different conversation you're having with your attorney. And we are always happy to work with them and discuss what you have with us, and if that's the case you would like to go back, amazing, then you can go ahead and do that. We wanna make sure that your peace of mind and the plan continues to follow you throughout this process. And then again, if there's any significant asset changes. This happens a lot, especially with, for example, the younger generation for me. Right now, I'm starting in, and I don't have too much. I have a lot of student loan debt and things like that. And so there's not much to protect in that regard. However, as I'm coming up and coming and hopefully start to establish myself more, the hope is that I have more assets. And then in that case, then I might need to go ahead and see, do I need a different plan than what I currently have? Or does it still meet my needs? Does it still work for me and the assets that I currently have now? Yes.
On the, after significant asset changes, what's the magnitude of change?
It can be really any change, honestly. That's why we always say, please give us a call or an email, because if you say, hey, I switched accounts over to this brokerage account, we'll be like, okay, does your beneficiary designations match? Are they what we had previously talked about? So there's just, it doesn't really matter on the type of change. It's just if there's any change, it's always important to take that review and take that second to take a look at it. And then the next one would be the estate tax law change. And so this one became very relevant, as you've heard both Michael and Ryan say. That's now gone up to 3 million, and that just happened back in July. So before that point, it was 2.19 million. And so that is a much different gap than the 3 million we currently have. And so if you were at that cusp, you were worried about it, and say you didn't want to trust, you preferred a will, but it did make you a little nervous. Now, there's a huge gap of 800,000 that allows you to grow in your assets before you have to factor that back in again. And so it's really just, if you're at those cusp lines, it's really important to see, okay, does this affect me? And if you're not sure, shoot us an email, give us a call. That's what we're here for. And it's why we don't charge for anything, for those. It's to make sure that your peace of mind stays with you and with the time, because everything is constantly changing. So next we have estate planning and those in control. So it's super important not only to have the documents set in place, but thinking about who's in control, when are they in control? Are they in control when you're alive or when you pass? And so we're first gonna look at who we kind of look to be in control. And Michael kind of talked about this a little bit, about first we wanna look to our immediate family. Those tend to be the sibling or your spouse or the children. Those are around you who understand your wishes the best. You're like, I don't trust anyone in my immediate family. It's just not gonna work that way. Then you wanna look at the next level, and that's your outer family, the siblings, the nieces, the nephews, things like that. If you don't have children then, but a sibling does, it may be looking at them because they are younger to help manage things. And if you still think, you know what, I'm just not feeling the family, then you wanna go next to your friends. Your friends, they know you very well, they understand you, but it is a difficult conversation to have sometimes. And so with that, you wanna make sure that if you do appoint a friend, you explain to them what that means. Because it is a hard job to task, sometimes especially during that grieving process. Of course, we're there to assist and help in any way that we can, and we want to give them guidance as much as we can, but we want them not to be blindsided by how much work might be in with this. And that's important to factor in. Is this friend a little type A, everything straight and narrow, Excel spreadsheet for the budget? Or, you know, we have our other friend who's type B and doesn't know what time it is. So there's pluses and minuses to different things. And then lastly, if you're like, I don't want anyone to have to deal with this in my life, like this is a job that's not worth doing it, I pass. Let's look at professional services. And that's something our firm does do, both for a will and for a trust. For a will, it's considered a personal representative. For a trust, it's the trustee. And so both of those are things to think about. And there's no right or wrong with any of it. It's really just kind of going down the layers is what we recommend. Because once you get to that very last one, it's gonna be the most expensive. So it is something to factor if that's a concern. If you wanna make sure your beneficiaries get the max amount, think about that. And then the next thing would be is how are they in control? So trustees of a trust, that becomes active once you start funding it, we sign it, and that's great. And so a trustee is active while you're alive. But then a personal representative, that's different. That involves your will, and that only starts active upon your passing. So a personal representative would not step in before that point. Other people that would step in while you're alive would be your agents, so for powers of attorney, for healthcare, finance, those documents, those are ones that exist while you're alive, and as soon as you pass, they go away, and then your PR would step in. And so just thinking about where are these people at in their current life? Are they close to me? As Michael said, he has family on the East Coast, and so do I. I don't have family in Washington. I moved up here. And so for me, it's a lot of friends that are kind of my support. And then the backups are actually the personal representatives and things like, or the professional services and people like that. Just because, of course, I want my friends to do it. I want them to understand my intent and my wishes because they know me the best. But they're going through a process. They are grieving during that time. They just lost you. Sometimes it's very difficult and you don't always know how people are going to react to that. So that's why in all of our documents for powers of attorney, personal representative, they do have the ability to say, no, I'm okay. I don't want to do this. I'm not in a place to do this the best way I know how. I would like someone else to step in. And then that's why we have those alternatives. Because you never know, especially for me right now, my friends, a lot of them we're kind of entering the time of seeing deaths around our life. And so we don't know how we're gonna act. I don't know how my friends will. But I hope that they would, but I wanna make sure that they have a backup so they don't feel like they're disappointing me, even though I've passed. And then the next one is talking about just when you're alive versus when you passed. And so again, that's just going back to power of attorney, your agents, versus a personal representative. Now a trustee, while that is active while you're alive, it often is you, the creator of the trust that is trustee. However, if you were to say, I want to create this, but I don't want to have to manage it, and you have a child step in. That happens often, and then they would be trustee during your life and after your life until they either decide they don't want to or something happens to them.
Question, there's also successor trustees.
Correct, and those would be those backups.
Okay.
Yes, so those successor trustees would be the backups. That's why we say they're the contingency plan, you know, if everything breaks loose, then we're gonna do this. We're gonna have people back up, so there isn't that concern of, they need to step down.
Yeah, and they can take over while you're still alive. What you didn't mention here is, what if you're alive but you're not, like, you get dementia or Alzheimer's?
Yeah, and
you're
so
not
if
able to take care of it.
If you see that and may occur, and we're gonna talk about that actually coming up, is failing to plan for incapacity. Because a lot of people don't think about, if you don't have anything set in stone, whether it be powers of attorney or a trustee managing the assets in the trust, then the person who is supporting you the best they can has to go to court to be able to make those decisions for you. And it's gonna make that process much longer and much more difficult and cumbersome for them. And they're already being put into a very delicate situation. And so with that, that's why we often have those successors. A lot of people, once they start to worry about whether they're getting dementia or Alzheimer's, or they're showing early signs of it, then what we do is we say, hey, maybe have a friend step up with you. You don't have to do it alone. You can have, or a child, or whoever you would like, whoever your backup is, have them step up with you, so then they can help manage this with you. So there are a lot of different options, just it really, as Michael said, it depends on the scenario. You know, most typical lawyer answer is, it depends, you know? And so some of the most common mistakes is, and it was lightly discussed, is not updating your beneficiaries. So for example, if you have an IRA or a 401k account and you give it to, mine initially was to my mom, and now it's at the point where I've been with my partner for so long, so I should probably switch that. I think he'd appreciate it. Or if something were to happen to her, who's my backup? Who's next in line? And that's something, even if you don't do a trust, you decide to do a will, we say, who's your backups? Who's your contingencies? We are all about having that contingency plan. So it could be spouse, and then it could be the children equally. And if everyone on a horrific accident vacation, something happens, then we sometimes will do even a third. Just because you never know what can happen in life, and so we want to make sure that we cover your bases. Because at that point, we won't know it until it's too late. And so it's important about thinking about, as awful as this is, worst case scenario. And then forgetting to fund a trust. That's a big one, because if you forget to fund your trust, it's definitely a glorified will. Very expensive will. Because if your trust is not funded, it is not active. And so it's just a piece of paper at that point. There's nothing for a trustee to manage because there's no funds in the trust. There's nothing it's protecting because there's nothing in the trust. And so making sure, going through that process, working with the financial institutions, our funding department, and seeing, okay, these assets should go into the name of the trust. These ones should be beneficiary designated. And we factor in the tax implications to that and kind of think about those pros and cons. Because for example, if you want your 401k to go to your spouse, but something happens to both of you, and then you're like, the kids cannot get it yet. Love them, they're great, but they're not at the place to get $500,000. And so if that's the case, then it may be, okay, maybe we beneficiary designate it into your trust, or to the provision in your trust that you have. It's definitely factoring each case individually, and that's why it goes back to, it depends. And so next would be communicating your wishes. And I lightly talked about how it's important to have your trustee or your powers of attorney know what your wishes are. So for example, if your power of attorney for healthcare, if there are certain religious beliefs that you have that you would like to have abide by, make sure they know, because your doctor's not going to, most often than not, unless you make sure that they confide in them. And let them know that it's important, I want this is what my intent is. And if you can do that to the best of your ability, then that's all I can ask you for. And so it's thinking and factoring those things in. And so next would be the coordinating all your documents. So that's some of the biggest mistakes we see, is that people will have conflicting documents. For example, your trust will designate an account to someone specific, but there's actually a beneficiary designation to it already. That beneficiary designation is going to override. It is going to cover it up, it is going to be superseded. So even if the trust says that, that doesn't matter, and so that's why we want to coordinate all of the documents. Or if, for example, you have a will, having a CPA agreement, and so your spouse, you can help avoid probate, but then if you transition to a trust, we're gonna revoke that, so we've got conflicting documentation. And that's why we talk about it's really important to check in, and before you check out, as Ryan loves to say, and see, are these really my wishes? Are these meeting my needs? Is this giving me peace of mind? Can I take a deep breath and be, okay, it's all okay? You know, it is gonna be an awful situation, but I know that I've done the best that I can, and I am happy with what I have. And so it's really just checking back in with that. And then I will introduce Ryan back.
Well, any questions for Amber before we go to the next slide?
Are we gonna
Yes.
discuss revocable and irrevocable trusts at all? That's something we take up with
That wasn't under the scope of today, but I would be happy to answer that after if you would like.
And so also, if you have, your assets, money,
Mhm.
and you have percentages going to each of the kids or grandkids or your best friend or whatever, where do you note that at? Where's the surest way for that to be executed?
So that would be whether it's beneficiary designated or if it's in your trust. And so often or not, we will see, okay, if this is better to have just a beneficiary designation, they can get it out right. It'll be receiving a letter that we'll send to that institution to make sure that it hits those points. But then if you had decided that, now, just want this lump sum to go to them out of any account, it doesn't really matter which one, then that would be named in either your will or your trust.
Okay, so it's, what I'm hearing you say is that if you want a spread like that, percentage spread to children, grandchildren, where do I put that? Just as a document in my book here?
It'll be in your trust or in your will. That's what if
Actually
you-
written out?
Yes,
By
it would be,
myself?
yeah, no,
By
we
us.
would, that would
By
be
you.
something we would do, correct.
All right,
Yeah.
thank you.
Mhm.
But I do want to, yeah, you have one more too, then we'll come back to the thought. Go ahead.
I just wondered in terms of the executor, if you wanted the family member to handle everything, taxes, taxes, for instance, on you, is that something you have co-executors, or you write it up?
Yes, so if you pick a personal representative or an executor, both of those are interchangeable. They are used often interchangeably, so be aware. If you decide that and they say, this is a lot for us to handle, can you help me? We will absolutely step in, we'll be co-agents with them, so we'll be co-representatives. And we'll do it in tandem together. And so it would just be an open communication between us and them as your PR.
The issue of helping out when a loved one dies, and the issue of when we act as trustees, we actually have trifolds on those. If you'd like one of those, feel free just to ask, and they'll forward it to you. We do have a very robust way to help people after someone has died. We have a 3-part letter for those of us that are clients. In your notebook, you have a section of what to do when a death occurs. It's now 4 pages long. It's the things that on any given day make common sense. And we're, oh yeah, I love this. But as soon as someone dies, common sense is out the window. And so it's things like, how do you order more death certificates? What do you do with a handicap parking permit? And by the way, you do not put it in a drawer and then 4 years later show it to your son who's an attorney. That's not appropriate because you're under contract to return it. All sorts of things on veterans benefits, who to call, it's just check the box. The second part of that letter is how to do an inventory of the people and the stuff at a death. Because what you need to know about the people and the stuff to set up your estate plan is not what you need to know when you take it down. And the third is our cover letter. And the cover letter is generally tailored to the estate plan of the one who died, if we know it. We have neutral ones. If a friend says, yeah, I have a friend who died, could you send them that death letter? Do you know anything about their situation? Nah, okay. We have a general one. But we generally tied to Taylor's did, so that's what we do there.
I wouldn't say this is a mistake, but it's something it took me a while to get my parents to do it. I was trustee on my parents' trust after, first mom died, then dad died. Few years before mom passed, she was getting ill. I finally got them to sit down with me and let me look at the trust book. I'm one of 8 children. They didn't want any of their children to know what all the assets were. They were concerned about infighting. I finally had to say, please put the training wheel on. Let me read it. If we hadn't done that, I would have been very lost as a trustee. So I guess as a favor to your trustees or your personal representative, let them see the documents while you still have the capacity to make
Right.
changes. Because we made some changes after I reviewed it. Worked with Mark Reinhardt here to do
Excellent.
that, yeah.
Good, good man.
And thank goodness, because
Yeah.
as a trustee after they passed, it made my life so much easier.
Yeah, the issue of revealing to your beneficiaries or your kids your estate plan, I used to think it was a generational thing. I've come to realize it's not. It's just a personal thing. And we have some clients that, because of the way they were raised, whatever circumstances, will say nothing no matter how much you beg. The others will go, oh yeah, open book, I gave them a notebook, told them to read it, bring it back, when you're done, let's go on. Here's a trick. If your parents or someone's being reserved, don't go ask them what they have. Let them know, hey, by the way, I've been updating my estate plan. Here's some of the things I'm working through. Talk to them about the different types of documents. Go through the different diagrams we use. Go through what you're doing as a power of attorney. Ask them, do they want to be part of that or not a part of it? Because you're not asking them, you're telling about you. 1, it shows you're open, but 2, cannot tell how many clients come back, I started doing that, and you wouldn't believe the questions they asked. They said, I don't have that document. Really? I know a law firm that can get you one. And it opens the door a different way where you're not confronting them. And so there are times that that's very beneficial. You were asking about giving things to people. Was it money or stuff?
Money.
Okay, never mind.
I mean, stuff is.
I had so much fun with the stuff thing.
Well, you don't have the stuff then.
The stuff thing is this. You, as an individual in Washington, have the ability to do a list. In our estate planning, the paragraphs that talk about personal effects give you the authority to do a personal effects list. On that, you can put down, so-and-so gets the grandfather clock, and then when they tick you off, you give it to them. You can put down all sorts of things. Please be careful, though, to be very descriptive, and if possible, include pictures. Because if you're selling an estate, you get the personal effects list, and it says 2 things. The blue vase on the fireplace mantle to this neighbor, because they have no kids. The plate collection on the kitchen wall to this neighbor. Again, she had no kids, so she's giving things away. Everything else is up to the trustee to distribute. Great. I went down there. I walked in the living room. I looked at the fireplace mantle. 3 blue vases. Great. Walked into the kitchen. How many walls does your kitchen have? Some have 3, most have 4. Guess how many plate collections? 4, 1 on every wall. Thankfully, I have someone who's very good at pricing stuff. So I took pictures, sent them to her. I love her company's name, Fruit Cocktail Collectibles. She does estate sales, it's perfect. Called her up, sent her the picture, said, any value? Nope, good. This neighbor got 3 vases. That neighbor got 4 plate collections. My job there was done. So with stuff, you can do that. And now you 2 are sitting real close together. Did you come together? Do you still claim it? Okay. As a couple, you actually can have 3 lists. One that is all the stuff you've accumulated together. But for our clients, we also give you each individual lists because there may be something, and I have no idea about their kids, there may be something that you've inherited that for 4 generations has been the firstborn male. And since you only have daughters, I'm making this up, it doesn't go to the daughters or your wife. It goes to your nephew or your brother. And there's things in both family lines that we've seen do that. If that's your case, you can put it on the individual list. One of the ones I'm working on right now is she apparently has a lot of jewelry. Okay? She'd like it to go down to the kids If her husband doesn't want it, he's going, well, I'm not gonna really wear it. That was actually what we talked about. And so what she put on her list, these are all to you. But in the event you want to give any of them away, here's who I'd like you to give them away to. So there's a lot of creativity with this stuff. The reason why both Michael and Amber were being very cautious when you guys asked questions about distributing money and putting provisions in your documents is because what is called the Secure Act, which deals with IRAs, 401ks, other retirement plans. The laws have changed there. And so when you're talking about giving away money, and Amber rightly said, sometimes it'll be in the document, sometimes it'll be beneficiary. That's because with an IRA, if I have $3 and I want to give to them my IRA, I make them the beneficiary, they will be required to take it out over the next 10 years, period. And all the income tax is paid on it. Additionally, they do not have creditor protection if I make them the primary beneficiary. I'll pick another name. She's been through an ugly divorce, and her husband, every time she gets money, comes after her for everything. If I make her the beneficiary of 1/3 of my IRA, it does not have creditor protection. And this daughter really doesn't know how to spend money very well at all. So I actually have a trust for her, I met her earlier in the hall. I have a trust for her for the rest of her life to make sure she has a retirement account. Well, if I make her the beneficiary, she actually can walk in the next day with a death certificate and take it all out and do whatever she wants with it after she pays the taxes. So instead, because in my estate planning, I have a provision that will take care of you the rest of life, protect from creditors, predators, state taxes, future beneficiaries. If I've done that and make that trust beneficiary, it has to come out in 5 years. So depending on the, not just if it's an IRA, depending on the size of the IRA, has changed what we've done on beneficiaries. Another factor on IRAs and giving them away is in the event you are charitably inclined. First of all, definitely talk to your financial planner if you're taking required minimum distributions, and you're doing that, make sure that you talk to them about QCDs, qualified charitable distributions, where you actually write your charitable donations directly from your IRA account. Can't be a 401k, can't be a Boeing VIP MSP, but from an IRA you can do that. By doing that, you don't pay the income tax, they don't pay the income tax. The IRS got wind of that and said, yeah, well, it has to have a life expectancy. So, you thought you got off scot-free. I have an IRA that I'm gonna give 50% to the charity and 50% to her. She has a life expectancy. Sorry. She has a life expectancy. The charity does not. But the charity will, but the IRS now says, because the charity has no life expectancy, but she does, it all has to come out now. So be careful. That's why it's hard to be real explicit on all of them, because all of these different dynamics play a part of it. Which is back to the question I thought was you about coming back in and doing a checkup or coming and doing an initial estate plan. I'm asked that question all the time on the phone. Could you just tell me how much it's going to cost? Simple question. I will ask you one question. If you answer me, I'll answer you. Was it you or you that asked about how much it costs to do an estate plan?
I just did a consult.
Oh, consult's free. I thought someone asked how much it costs to do one. That was over here. The reason we can't do that is my question is, I would like you to build me a house. How much will it cost? Because yes, you can do estate planning off the internet. We actually did a seminar about that, by the way, it's really fun. But you can do that, and for some people, that's better than nothing. But people come to us because they want to make sure it's personal. And so in the same way that if I ask you to build me a house, you're asking how big, how many rooms, what quality of workmanship, what are going to be all the fine parts of it. Guess what? That's what we do. And for those who are our clients, they come in with some questions. And generally, they leave with more than they came with. Because it's our job to ask you. I was working with a client this week, husband, wife, 18-year-old, 15 and 13, I believe. And they have a very old will, used to have guardianship in it, now they have a state tax problem. Their financial planner said, you probably should go talk to Brian. We're going through everything. So I got to the final really rude question. Says, tell me something. Both you and your husband have died, and all 3 kids, who gets it? What they've already told me is his dad's died, his mom is now being bullied by one of the other kids to end up absconding with all of her money. On this side, both their parents are alive and doing very well financially, been gifting, and they're trying to get rid of it so they don't pay estate taxes. The couple, real estate, $10 million. I said, great. So you 5 died, $5 million is going to go to your parents who already have an estate tax problem. As to you, $5 million is going to go to your mom, which your brother's going to end up with also. Oh boy, were they not happy. That's when you make it worse. Kill her first. It's all his, because they used to have a community property agreement, and now the brother can take off with all $10 million. They are going, how do we not die before we hire you and get our estate plan? Don't schedule. Okay. Those are issues that help to fine-tune some of the things you are asking about. The other issue of asking about what assets go in a trust or not in a trust, we've talked briefly about you cannot put a retirement account in the name of a trust. It has to be in your name. The reason why most people do not put a bank account into the name of the trust in many situations is because if the bank account's in there, some institutions where retirements come in, pensions come in, other money comes in, they want that to be in your name only. They want it to be identical to where the money's coming from. So for most bank accounts, you make a beneficiary of the trust. A brokerage account, most times, is just in the name of the trust. When you come to real estate, yes, absolutely. You should put every piece of real estate in the trust. And you will hate me. Because if you have a rental property with a mortgage on it, and someone tells you to do that, and you transfer that in the trust, the mortgage company can call that loan due immediately. Danger. There are other ways to do that to protect it. So that's a part of the reason why when we do the initial meetings and we take a couple of hours, we are going through those assets. And when it talks about preparing for an update meeting, and we talk about all the different things and why we send you a questionnaire, which we get all the time. Why'd you send me another questionnaire? Don't you have all the details? The first thing I do says, tell me the address of your kids now. Huh. None of those addresses are the one you gave me last time. Oh. Do you still have these institutions? No, we changed those. Oh. That's what you're doing, is you're going through those to help us to know. The other part of that is that all the things we've been talking about today is your goals and desires may have changed, your beneficiaries may have changed, the people who you want in control, the people you want to leave it to, may all have changed. So be very careful, and that's why when the ladies send you a questionnaire, please bring it. Send it in a week ahead of time if possible, because we want to review that, to look at it, to see if goals and desires have changed, and if there are things we need to make sure we talk about at those meetings. Review meetings are very, very important, and I wholeheartedly agree to what you're saying. A birth, a marriage or divorce, debilitating disease, a death of anybody, all of those things are reasons to take a look at it. But certainly if nothing's happened every 4 years, you should come in and see us to make sure that it is what you want it to be, and it will now accomplish your goals and desires to give you peace of mind and control. Very important. All sorts of things. A couple of the things, questions, please.
I thought trusts have a different tax bracket schedule, or is it only certain items in the trust get taxed like you normally would and some are trust related?
Okay, yes and no, and she's not a plant. That was a very good question. What she has heard is that there are certain types of trusts that the income tax brackets are much more condensed. that is true, that is called a irrevocable trust.
Oh, okay.
And it may be one that you build that was a standalone you're money into now. It may be one that is set up in your estate plan to happen after you die. When you have a revocable living trust and you are alive, it's your social security number, your income taxes. And even as a husband and wife, if one of you dies and you're doing protections for the spouse, the side that is irrevocable of the one who died, they have those compressed tax provisions, except between spouses, one of the rules the IRS wants is they want all the income annually moved over to the survivor. And CPAs know how to account for that with the K1 and all this other kind of stuff, which is why I'm not a CPA.
Well, you mentioned brokerages actually in the trust, and that's what triggered my question.
Revocable trust, correct? Absolutely. Yep. Yeah, that was one, answer that one. Yeah, you did that one. IRAs, that's always a good one. We talked about that. Tax limits. Oh, the state of Washington state taxes. Again, this is why I'm not a CPA. Is anybody here a CPA? No, I'm gonna compliment you if you are, because it's good. Plus I have work for you to do. It's hard to find good CPAs right now. When they did the new estate tax, Washington State, and they bumped it from 2.193 to 3 million, and now they're doing others, those that do the numbers and do the machines, it actually shows that if your estate is under about $7.7 million, the new estate tax limits are actually less than they would have been under the old system. It's only when you cross over about the 7.5, 7.7 that then the higher brackets, with the fact that it's a different schedule and limit, actually is more. And if you're married, that's for each of you. So just be aware that for a lot of people who individually are under the 7.7 or 15.4 as a couple, for the state of Washington, you're paying less income tax. But like Michael said, when they give you something, they take it away. Once you cross that limit, you're toast. It goes up pretty darn quick. So just, I want to make sure that people are aware of that dynamic is in there too.
Do you have a trust in the state you're resident in?
The question is, do you have to have a trust in the state you're a resident in? Are you talking about a revocable living trust or an irrevocable trust? Okay. Normally, the purpose of a revocable living trust, it doesn't change your income tax status or location status. And so when they look to residency, and they are cracking down on residency in many states and not in others, and they're changing their tax codes to apply if you have real property in that state. The predicament you have is attorneys are normally only licensed in certain states. We are Washington, okay? And because of that, I have a lot of clients who don't live in Washington. But when they come here to visit family, they've done their estate plan here, and the state governing it will be the situs of Washington State. So I'm okay to do that. But I do have clients that are moving to another state, and I know that question came up earlier too. We actually give out a list of the top questions to ask when interviewing an estate planning attorney. Because we used to do seminars for the federal government, and they came from all across Washington, so we gave that out. And we just encourage that. You take that with you if you're gonna move to another state, and you keep looking for an estate planning attorney that can answer all those questions. It was that time when David Letterman's top 10 lists were the thing, or whoever they were. So we had, the top 10 questions to ask. The most unique story of that was we did the seminar downtown, gave out that in. About 3 months later, I go to meet here in our CTEC area, and a gentleman's there. And one of the questions I always ask is, so what would you like to learn? Where do you want to start? What's hot on your mind? He goes, well, since you've asked, he reaches his pocket, pulls out a paper, I got 10 questions I want to ask you. I didn't realize he had been at my seminar, so he brought my own questions back to me. I knew the answer. So it's one of those things that that if you're going to have real property, you're looking, depending on if it's in your name. If it's rental property, then you wanna talk about LLCs, you wanna involve a CPA, you wanna involve somebody in that state. And if you're talking about residence issues, you really need to look closely at how they're changing, because they really are changing.
So can you choose like which state is most beneficial? Take what I have and then say, I would like to do it there.
I have those that try them,
Okay.
but that's why you have to look at the resident issues. Because just to have bought a piece of property there, Washington is aware of that, and if there is not a tax there, but your residency is here, they're gonna try to drag it back for state tax purposes. Woo-hoo. And most will. That was another question I forgot to come back to. It's why I wrote that. There was a question about do the beneficiaries have to pay a tax? There are two types of taxes in the United States on assets after death. One is called an estate tax, the other is called an inheritance tax. Washington is an estate tax, which means they're greedy, they want their share off the top, and whatever's left can go down to the beneficiaries. There are other states where they say, no, once a person dies and gives out the money, you have to report who got it, how much they got, and where they are, and we will go after them in their states, and they themselves will have to pay the tax. Two completely different things. We are an estate tax state, so that's why it's not as if the beneficiary has to pay the estate taxes. So people take that to mean if a beneficiary gets an inheritance, they don't have to pay any taxes on it. No, because remember you three inherited the IRA? It's untaxed money. Doesn't matter what the estate taxes is or what I've already paid on that. Every time you take some out of that over the next 10 years, what you take out will be increased in your own income taxes. It's not estate taxes, it's income taxes. So some annuities, I really should have you define all those. I'm a friend of the audience, wealth advisor areas. And some annuities come out of an IRA and it's 100% income taxable. Some annuities are post-tax, and it's only the growth in there that is taxable. However, we were working with a client and the financial planner, thank goodness, and the CPA, and we were talking about how to divvy things up. And the CPA said, hold on a minute, hold on, let me check. Yeah, I know it's about 175,000 right now. They put 20,000 in to start with about 20 years, they keep rolling it over. 150 was income taxable. Good investments, very good investments. So you have to look to those things. That's why we call it the three-legged stool. The financial planner, CPA, and estate planning attorney. We're all here to help keep you out of trouble with different institutions. Okay?
I have a question.
Please.
If you're interested in setting up a trust, do you recommend transferring the title to your house and car and assets into the trust so the trust owns that?
Yeah, let's come back to that because that's one of the other ones. Very good. When you set up a living trust, a revocable living trust, you're in control of, and that you are, it's your social security number and everything else. When we do that for our clients, we actually have a homework sheet that we give to you. And for all real property, you have to provide a copy of the deed, the tax parcel thing they send you, what your property taxes are, homeowner's insurance, with all liquidity, full copies of all statements from brokerage companies, from banks, from your office if you have a 401k, information about life insurance, information about businesses such as LLCs, things that you have, you're providing to us. And what our team does is to look to every single one of them. Because at a brokerage company, there may be 4 different types of assets. There may be a traditional IRA, which will go one way, a Roth IRA, which will go another way, a brokerage account, which will be titled a different way, and then a life insurance policy. And so we have to send a letter to them saying whichever one of these you have, here's how to make a beneficiary, or here's how to title it. And so what you want to make sure you do, if you do decide to set up a revocable living trust, is work with a law firm that does the funding. There are a lot, which is filling it up. There are a lot of law firms who give you a trust and then give you an instruction, say, don't forget to go fill it up. Okay? Where are you gonna find information about that? We have funded a lot of other people's trusts done by other law firms, because no one did it, and they did it wrong, they tried. So it's very careful you do that. And you've heard me mention homeowners insurance. Because of a really stupid lawsuit, homeowners insurance companies have now asked that if you set up a revocable living trust, please notify us so your trust can be a secondary insured. And then if it's an IRA, a 401k, 403b, Boeing VIP FSP, we need to know your beneficiary provisions in case you got 3 kids with all different types of dynamics before we can even decide which way it should go. And so, yes, we have a team that does that. Not all law firms that set up trusts do, but we've just found too many times where it's done wrong. That's one of the major reasons doing a living trust is more expensive. You're not only paying for a bigger document, you're paying a law firm to fund it. Do that if you're a marketer. Hi, come to our firm. If you want to do a living trust, it'll cost you more. Okay? Tagline, it'll work. But it's hard to do that. So that's why at that initial meeting, when we talk about the assets, which again, the reason to fill out the questionnaire, initial or checkup, is because we go through every single one of those assets to determine it. And like Michael said, unless it's a collector car over $50,000, motorhome, it doesn't go in the name of the trust. Now, most boats aren't above that, but if they're above that, they would. And for those of you who really own a plane, I know, yeah, it does too. So all of those are different things that we look individually based on your circumstance. And whichever one it is, we'll work to make sure it's under the umbrella. Yes, please.
So, similar to what he was asking about putting real estate. So I went through a situation with my mother. She had deed upon death.
Dave, transfer on debt.
Yes, transfer on death. But I ended up she ended up on Medicaid, and we kept the house and didn't realize now I have a second mortgage
You do?
on the house I inherited.
Yep.
To pay back the state.
Yep.
So, looking at my children in the future, how should I put the house?
Okay.
You know, instead of deed upon death, in case they, get into the same situation.
Right. Here's the crux of this question. The crux is Medicaid.
Yeah.
And the crux is Medicaid keeps changing the rules. It's what time, so no, I'm not going to.
310.
3:10. 3:10?
Yeah.
What time are we supposed to be done? If you gotta leave, feel free, but I'm gonna have some fun for a few more minutes. Okay. Medicaid is 3:10. Ooh. And for all I know, they've already changed the laws again today. That's how fast they do it. What she's talking about is the consequence was not that it was a transfer on death deed. The consequence is if a person goes on Medicaid and has any real property, and Medicaid pays out money, they are entitled by law to put a lien against whatever real property there is. It has nothing to do whether it's transfer on death. It has nothing to do whether it's in a living trust. It has nothing to do whether it's in your name. That's just what they do. And it's a shock to people's system. The other thing is they send really threatening letters right away. I have a person that actually works with families who have reverse mortgages, Medicaid liens, to help them to deal with it to where it's not as odorous as the letters make it sound. The issue there is your mom didn't get good advice when she was getting ready to go on Medicaid. I am not, let me repeat, on recording, I am not a Medicaid attorney. But they have trained me. And what they trained me to tell people is, if you're gonna be thinking in the next 5 years that you might run out of money, or one of your families might run out of money, and may have to go on Medicaid, in the next 5 years, you'll be wise to go talk to an elder law Medicaid attorney. Because if she had, instead of the transfer on death, gifted to you guys the house right before she went on Medicaid, they wouldn't have put her on. Because there's a look-back period for 5 years. And they said the value in that house would have lasted X number of months, so until that happens, we're not paying. So she may have gotten advice and said already, look, I'll put a transfer on death, hopefully I won't use that much, but I need to go on Medicaid, I can't even gift it to you right now, whether it's in a trust or transferred out, so therefore I'm going to just bite the bullet, no, there'll be a lien. But someone should have told the kids. Someone should have told the kids. She's right. And by the way, on telling the kids, I was gonna mention that, again, for those of you who know me, you know my sense of humor. We do family meetings, and they're 2 hours, and they're $500, and you bring in whatever family you want to. Bring in the kids, bring in the in-laws, bring in the grandkids. We've had huge groups and small groups, and we go over the general rules of estate planning. We can go over even what the different types you have. We don't have to go over finances unless you instruct me to. But that's where I get to say things you don't want to say. So, kids, so when she has set up her estate planning, and it's going down to her kids, but the in-laws truly are the outlaws. And I want nothing going to the outlaws. It's supposed to go to my grandchildren. Well, how is she going to say that to him and her? I can, and I can have fun doing it. And we do. So again, telling families, if you're of the type that wants to at least say something, but not even necessarily say all of it, we're good at that. Those are fun. Okay, I'm looking at the different questions you guys have asked. Last slide, by the way, what you get to do, what we get to do, what you manage annually is your documents, your life. Look at them, see what changes are there. We have some clients that come back every year. I think they like coffee, I have no idea. We have others that it's been 15, 20 years, because every 4 years they look at it and go, looks good, see you in 4. It's up to you. What is our job? If you come in, we will review who's in control, who gets it, how they get it, when they get it, and how you do with your assets. That's our job. Technically, our job is to ask the annoying questions. That's what we do. Amazingly, we're good at it, you can still come in. Who knows? When to schedule. Again, I have people that, it's like clockwork. And for them, some it's 3, some it's 4, some it's 5. And yes, there are a few that it's annually. Okay, we have a good time. But you want to at least mark down when you should review. Look at how long it's been since you did it. And make sure you make a note of when you should come back and take a look at it. And when you want to schedule something, and with this weekend, but call. They got the computer up there. If yours has been that long, they'll look it up and find out when, and they'll schedule it now. We also review estate plans from other law firms. There's a lot of people who try to find the attorney who did theirs and can't. There are others who look at their estate plan and go, never really did like that attorney. Hopefully it wasn't us. And so if you have a document that you did at another law firm, you're welcome to come to us. It's not going to cost you to come to the meeting. And it takes all of about 10 minutes to review the documents you have, and then to let you know what are they covering, what are they missing. But it is important that you take the time. That's the whole purpose of today's meeting, is to take the time to say, why do we need to take care of our estate plan? Things change. And so please do take the time. But with that, I appreciate you being here. Thanks for coming. Michael and Amber will be up here, and the ladies able to answer questions. And if you really do want to set up something, they're the goods. You tried to throw